going to invite people slowly take its way across the country toward us. Yeah, it kind of feels that way. You know, it's like, do you remember the movie the book The Stand? I never saw The Stand. Or read it, yeah. Oh, there it is. There you are up there. Cool.
Yeah, so it's nice. I love this. You're able to see it instead of having to turn around. But yes,
I mean, I realize like this. Yeah, it's a good chance that they're going to say right about that time.
yeah.
Oh, there you go. There you are up there.
I was supposed to go this year, but I'm
Yeah,
going to be in Vienna, so
Oh.
I'm pretty sad that
Or
it's
not.
going to be cancelled. Or not. Yeah.
But Barbara said that you need to drop it out. She said that she was going on vacation. That was nice. But,
Although depending on where you are, you know,
yeah, oh, there you go.
travel somewhere and then not be able to get back. You would take deltas from Milan to New York.
But Lisa Camp is spending the weekend with Paradise Island. I could get stuck there.
Sure.
I think I already have links for that.
Although depending on where you are, you know, basketball tournament, travel somewhere and then not be able to get back. You would take
Battle
deltas from Milan to New York.
No, battle for Atlanta.
Oh.
For Atlanta. That's it. And Ohio State is playing too.
Sure.
Two favorite teams.
Right.
That'll be really fun.
Omaha.
Okay.
You're the Royal Ohio.
Yeah, that's what we got.
I put it from the
So they haven't had a really super team since
Not for a while.
Bill Bradley, right?
No. They were these upstarts. They would go
Everyone
powerhouse at one point.
That'd be really fun.
That's true. They would just pass it. 2 in a row.
Okay.
Royal Ohio.
Yeah. Hi. It's nice to see you. Thanks for coming the other day for the panel on the Warren Commission.
Oh, that was great.
That was really great.
I
They were
wanted to talk
these
to
upstarts. They would go
Judge Perry
Everyone
Jackson's
else,
family.
yeah.
It's having the statue.
That's true. They would just pass it.
I wanted to put a picture in here and give them away for scholarship.
There is a picture in here.
I know, but don't give them away for scholarship. But anyway, they're having this dedication.
It's nice to see you.
Okay, you are. Okay, all right. I just want to make sure because I don't want it to be a flop. I don't.
No, I've been on the committee. I did
Okay. Oh, that was great.
That was really great.
I wanted to talk
These
to.
upstarts. They would go
Okay, all right. It's having the statue. And Judge Adrian, we don't know if we should like send a picture in here and give them away for scholarship.
There is a picture.
I know, but thank you. I like how nice showing them all the time.
It's nice to see you.
Okay, you are. Okay, all right. I just want to make sure because I don't want it to be a flop.
No, I've been on the committee. I did.
Okay. Oh, that was great.
All right.
Good
Good afternoon, everybody.
Okay, all right.
We'll go ahead and get started. For those of you who don't know me, I'm Michael Scharf. I'm the co-dean of the law school, and it is my great pleasure to introduce today's presentation. We are going to have Harrison Mabari, who you will hear more about in just a minute, speaking about use Cogens, norms, derogation, and limitation of human rights. Good afternoon, everybody. We'll go ahead and get started. Oh, that's really weird. Okay, so that was me on the echo chamber. But as I was saying, Harrison will be speaking about use Cogens norms, derogation, and limitations of human rights, the case of Kenya and South Africa. And I do want to say on a personal note that I have known Harrison for several years since we hosted a Benjamin Ferencz prize for distinguished writing about international humanitarian law. And people from all over the world contributed to that, participated in that prize contest. And the runner-up at that was a law student by the name of Harrison Mabari, who has gone off and done wonderful things, which you'll hear about in a minute. For those of you who are just coming to one of our events for the first time in a while, this is hosted by our International Law Center, the Cox Center. And the Cox Center just this month was ranked among the top 10 international law programs in the country by Pre-Law Magazine. The Cox Center and the International Law Program, including the Institute for Global Security, Law and Policy, which is run by Associate Dean Avedon Cover, have been hosting distinguished lectures and conferences all year long. And we were just selected to host the mid-year meeting of the American Society of International Law. That will be on the 29th, 30th, and 31st of October, 2020. That will include a dinner at the Rock and Roll Hall of Fame, and we hope many of you will join us for that event, as well as the other exciting events we have. Two other things just to mention about our international law program. One is that our faculty were involved in researching and writing a report about the genocide against the Rohingya people in Myanmar. And that report was cited a dozen times by the International Criminal Court in its most recent judgment on the genocide of the Myanmar people, the Rohingya people of Myanmar. And then finally, I would like to mention that our Jessup International Law Moot Court team went to Chicago and won the Chicago region. They won the Best Speaker Award. They won the third Best Brief Award, and they are off to the international rounds coming up. Meanwhile, our VIS International Arbitration team has been winning a number of the pre-moots, and our International Criminal Court team will be competing soon. Lots of exciting things going on around here, and not least among them is having Harrison Mabari join us today. And I would like to have Associate Dean Avedon Cover tell you more about our guest speaker.
Good afternoon, everyone. Thank you all for being here. I'm really particularly thrilled to introduce Harrison Mbori as our speaker today. I got to know Harrison just a little over a year ago when I had the privilege of teaching and working at Strathmore University School of Law in Nairobi, Kenya. And on one of my, or maybe my first day there, they didn't really know what to do with me. I don't think they had a key for my office or what have you. They were very apologetic. And I said, it's okay, I just want to watch, maybe I'll attend a class or something. And they looked very nervous, and then they said, okay, yes, yeah, we know exactly who to send you to. And that is how I met Professor Mbori. I actually was privileged to sit in on a 3-hour class lecture on international trade. And I think it is safe to say right from there I knew I was in the presence of an amazing teacher, an erudite scholar, and thought to myself right then and there, how do I get him over to the States and maybe teach at Case Western. Well, as luck would have it, Harrison is now pursuing his SJD at Loyola University Chicago School of Law, so not too far away, and was able to convince him, corral him to come here and speak to us on this important subject that many of us here may not be so familiar with, the constitutions in particular of Kenya and South Africa. You know, in contrast to the U.S. Constitution, which is exceedingly old and exceedingly brief, the Kenyan and South African constitutions are quite new and voluminous, quite extensive, enshrining human rights and various other provisions within them. And while there is certainly a very positive tale to be told of those features, Harrison will also, in his fashion, no doubt, give us also a reality check and share with us some of his concerns and critiques of these documents and the way the jurisprudence there has played out. As you have in your materials, Harrison is an SJD candidate, as I mentioned, but he also holds a Bachelor of Laws from the University of Nairobi, Kenya, and an LLM degree in International Law and Alternative Dispute Resolution from Loyola, Chicago. He is an advocate of the High Court of Kenya, a doctoral fellow at Strathmore Law School, where, as I mentioned, he teaches international trade law, but also human rights and alternative dispute resolution. He's an accredited mediator, and his research interests and what he's focusing on for his dissertation are on the regional courts in Africa. But please, enough of my words. Please join me in welcoming Harrison Mbori.
Thank you. Thank you, Dean Schaff and Dean Kova, for such an illustrious introduction. That's not, I was seated there wondering if all that is me. It really isn't. So I'm very happy again to be here today to make this presentation on part of what is a bit of my developing research on international human rights law, especially human rights law as is focused on Africa. As you can see, my paper is titled Use Cogens Norms, Derogation and Limitation of Human Rights, the case of Kenya and South Africa. Let me give a bit of a disclaimer. I'm a Kenyan and I'm not a South African. For some time now, I've been a little bit against doing sort of, deep diving on comparative analysis. So I really do know a little bit more about Kenya than I know about South Africa and about any other region. So in case I tend to mention anything that is inaccurate about South Africa, just forgive me about that for now, but I might know much more about Kenya. So the outline of my talk is going to be that I'm going to give a general introduction, which will be general to really locate this discussion. Then I'll try and do some framing of human rights discussion, at least in these two countries. And then I'll try as much as possible to give you the narrative of what I think is a fragile hegemony of human rights in Kenya and in South Africa. Then some social and justice and social and cognitive justice issues that I think are important for us to think about, and then I'll speak about what I think are important, or the three evils of what we call the three evils of Western modernity that strongly affect human rights, at least in my estimation, in Kenya, in South Africa, and in Africa generally. So that's the outline of my presentation. So this quote is an interesting quote from what I consider to be the most famous or the biggest case in terms of human rights from South Africa, the case of State versus Makwenyane. The quote says, that the South African Constitution is supposed to provide a historic bridge between the past of a deeply divided society characterized by strife, conflict, untold suffering and injustice, and a future founded on the recognition of human rights, democracy, and peaceful coexistence and development opportunities for all South Africans, irrespective of color, race, class, belief, or sex. Essentially, what Justice Charles Colson is saying is that the Constitution of South Africa is supposed to be transformative. Carl Clare, who's a scholar at Harvard, has called this type of a constitution a transformative constitution, a constitution that tries to completely break the mold of what is a past system into a new transformative system in terms of social injustices, in terms of discrimination and the kinds of suffering that a state has gone through. And this is true for in the case of South Africa. I would say in a very large extent that this is also true for Kenya, especially after 2010. But before I get into that, perhaps let me just try and draw for you a little bit of locate these two countries in Africa. So Africa has 54 states, and as I realized recently, there are some that are contested, and there are some that sometimes are not, counted. And Kenya is located in the east, the green part of Africa, while South Africa is located at the tip in the south. And so, at least in terms of location, that's where these countries are. You could consider them, strong hegemonic countries in their region. South Africa in the south, Kenya in the east. Of course, there are other hegemonic countries in other areas of Africa, but these are the two countries that I'm specifically focusing on today, and I would like to make a little bit of presentation about. Historically, it is important to mention that both countries were colonized by the Britons, but most of Africa was colonized by one country or the other after the Berlin Conference in the late 19th century. And many European countries, including Spain, Italy, France, Britain, Germany, Portugal, and Belgium, got a piece of what we have normally referred to as the African cake. And indeed, they divided the continent at this point as if they were dividing a cake, because if you look at some of these boundaries, you'll see that some of them are just straight lines that are drawn in order to divide the continent. The effect of this is cataclysmic. Sometimes, and I really need to mention that the effect of dividing the continent in this way was cataclysmic, because certain nationalities, certain communities were divided completely into half and found themselves in different nations or in different countries. I consider that there is not a single nation state in Africa except one, which for all intents and purposes can be said to have been in one way or the other. I don't like using this phrase, but a failed state. So for a country to be a nation state, it has to have strong homogeneity in terms of culture, in terms of language, in terms of the people who are there. And that nation state that I'm talking about in this case is Somalia, a little bit to the north eastern part of Kenya. There are two curious cases here that you might be interested in, and that is Ethiopia and Liberia, which incidentally were not ever colonized. Liberia because of the influence of the United States, and Ethiopia because of some sense of military strength and exceptionalism, though the Italians claimed that at some point they colonized or had a protectorate over Ethiopia. So every country essentially in Africa has a colonial history that is related to Europe. And that is important for me as I frame this human rights discussion, because this is a very important aspect for us when we are trying to think about Africa. And this is important because I want to center history. I think history is important, and I think we will not be able to at least understand these two countries without thinking about history. That is Kenya and South Africa. Now, how should we think about what the United Kingdom did, at least in the countries which it colonized? In this sense, we are speaking about not just the three that are mentioned on my slide, but even more. What essentially happened is that the culture, the laws, the way of being of these nations got a very Eurocentric, look, so to speak. So most of the cultures, most of the way of living of the peoples of these countries was sort of transformed and taken over. Most of the time, not in terms of that these people accepted it, but these were very violent episodes. They were not episodes that were accepting episodes, that these communities in Africa accepted the Britons to come and take over them. They were completely violent episodes. So every time I hear this revisionist history that says, maybe the Africans might have benefited or might have welcomed the colonialists, I tend to think that that is really a revision of history that is wrong and should not be accepted. So colonialism was violent. It was not just violent physically. It was violent in terms of justice, both social justice and cognitive justice. It was violent also culturally. It was violent legally. So it was violent in the tangibles, but it was also violent in the intangibles. And good examples we have here of Kenya and South Africa to think about. And that now introduces us and makes us ready to think about these two countries, now that we have seen a little bit of what we're talking about in terms of how they sort of get to be formed. Now, in terms of constitution, South Africa has had 4, but it is only one among the 4 that is actually a constitution that is worthy of a name, a constitution. So in the 1910, the 1961 and the 1983 constitutions are all constitutions that are developed for the white majority. They are constitutions that in the white minority in South Africa. They are constitutions that institutionalize the system that has been called apartheid, which is separation. And here in the United States of America, this is not very hard to understand because the idea of separate and equal had existed for a long time, and many people who are African American can understand the history of a system that separates based on races. And that is the history of South Africa. Up to as late as 1990, when Mandela comes out of prison, and a new constitution that has a wider democratic acceptance comes in. And that's how we end up with the 1996 Constitution of South Africa, which now grants full suffrage, which, if you read carefully in its preamble, is specifically saying that this constitution wants to transform this society and to break it from a past of injustices, especially injustices that were perpetuated by a system of apartheid, to a country that now accepts full suffrage and is interested in equality, is interested in democracy, and is interested in full suffrage of everyone, including the blacks and the whites. And South Africa is interesting because at this point, South Africa then becomes what we call a rainbow nation. If you look at the flag of South Africa, you'll see that even under that, they really want to show that South Africa is a country that includes the people in South Africa. And that's what the preamble says. Everyone in South Africa is South African, whether black, whether colored, whether white, they are all South Africans. And that is the spirit of Nelson Mandela. And to a large extent, that is why Nelson Mandela is treated as, a global hero, because that's what Nelson Mandela stood for. But as you'll see, these ideas are now being contested. As you'll see, certain South Africans are not as happy about the fact that South Africa is a rainbow nation. And that's part of what I'm going to speak about. Now, Kenya is, on the other hand, a little bit different. It does not face the same racial concerns that South Africa faces, but it does have the colonial concern that South Africa went through. And Kenya gets its independence in the 60s when there is a wide wave of the independence movement in Africa, and that's how we end up with the 1963 independent constitution, which for all intents and purposes was a good document. When it was being negotiated in Lancaster, Thurgood Marshall, who some of you will know very well as being the first African-American, Justice of the US Supreme Court, was one of the people who wrote and was involved in writing the Kenyan Independence Constitution, and it had a Bill of Rights, and it really tried to ensure that the country was being handed to the black majority in a way that they could be able to govern themselves. But this constitution went through so many, sort of amendments that by the time we are getting into the early 90s with the fall of the Berlin Wall, Kenya was a de jure one-party state. And this happens to very many African countries. The thing that Kenya is lucky to have avoided is a bloody coup. So many African countries went through bloody coups that at some point you would call certain sections of West Africa that goes all the way up to certain section of East Africa as the coup belt, because of just the number of coups that had taken place. And Kenya did not. At least it had an attempted coup in 1982, but never a full-blown coup that changed a regime. So that, in that sense, Kenya survives, not being part of the coup belt. But what it doesn't survive is having a single-party state that is highly repressive. So by the time Kenya is getting a multi-party state in 1992, many of the opposition parties, many of the opposition, sort of opposition parties that had been trying to assert themselves in Kenya had been nipped in the bud, had been clipped, and there had been many instances of assassinations. So what happens in 2007 and 2008 is interesting because we had what is the closest to a post-election violence that really brought the conscience of the nation up. And that, I can say, is one of the biggest causes for the 2010 Constitution. So the 2010 Constitution comes up mainly because in 2007 and 2008, there was a bloody post-election sort of violence that killed more than 1,000 Kenyans. So that is how we end up with the 2010 Constitution, which, like the South African Constitution, has these values of democracy, a very robust Bill of Rights, and an aspect of transformativeness, saying that this Constitution is supposed to transform the country from the past of discrimination, from the past of lack of, full-blown constitutional democracy, to something that is different, something that speaks about equality, governance that is more for the people and by the people, in the sense of republicanism that many people think about in this country. So there we have our two constitutions, the 1996 South African Constitution and the 2010 Constitution. And so we sort of want to think about, what about these constitutions? What about human rights? What about the norms that are present in these constitutions? Here is just a comparative, sort of a slide to think about South Africa now with a population of approximately 60 million, and Kenya with a population of approximately 50 million. Both countries, have their official languages that include English. South Africa has very many official languages, 11 of them. Again, part of that idea of being a rainbow nation is just having as many as possible, as inclusive of languages. Both countries self-identify, at least based on my international trade law knowledge, as developing countries. But South Africa is an interesting country because before it came out of the apartheid era, in the WTO, at least South Africa identified itself as a developed country. Then, after it came out of apartheid, because of many of the benefits that come out of self-recognition as a developing country, South Africa now insists and self-identifies as a developing country. And so you might be interested in the politics of self-identification of who's a developing country and who's not. At least here in the United States, is the question of whether China, as the US views it, is a developing country or not. That's a different discussion altogether. So in terms of framing the human rights discourse or discussions, we want to think about whether the Kenyan, the Kenyan Constitution and the South African Constitution provides for these jus cogens norms. But first of all, it's important to say that jus cogens norms are norms essentially that cannot be derogated, or these are norms that it doesn't matter, and especially when there is a state of emergency is when norms can be derogated. And derogation is different from limitation. A derogation is a complete suspension or taking away of a right, while a limitation itself is the enjoyment of a right, at least up to a certain extent. So it's something like a restriction. It's not that the right is completely taken away. And so it is very rare for you to hear about derogations because they can only occur in certain situations where there are public emergencies. Okay, and now in the recent past, we now know, now we have the coronavirus. In case of a public health emergency, there is a possibility that there can be a complete derogation. And the concern is whether, to what extent does that derogation take place, and to what extent does a limitation take place. However, there are certain norms or certain rights, at least in the international regime, that are identified as non-derogable. So these are rights that you're not supposed to derogate from, no matter the situation, at least at the international level. Normally, to identify them is a bit tricky. To actually get to know what really is a non-derogable norm is tricky. But if you go to the ICCPR, the International Covenant on Civil and Political Rights, you might get in Article 4 a list, a tentative list. And that list includes the right to life. And at least for me, the right to life, in terms of not arbitrarily deprivation of the right to life, because as we all know, the right to life is in many ways limitable or derogable. This ties very closely to something that I will center on in this discussion, which is the death penalty, because this is an important discussion. For a long time, it has been an important discussion in this country and in international human rights discourse. But there are certain ideas like, torture, cruel, inhuman, and degrading treatment in terms of punishment, and tying that to the death penalty, slavery, servitude, and compulsory labor, or freedom of thought, conscience, and religion, as examples of norms that you can say these are non-derogable norms, at least as under the ICCPR. Now, the Article 25 of the Kenyan Constitution says that there are certain rights that may not be limited. And if you look at this language carefully, you'll see we're not talking about rights that may not be derogated. We're talking about rights that may not be limited, which is a different sort of a situation. And there you have most of these rights, including the right to, a fair trial, which some people think, that is a right that can not only be limited, it is a right that for all intents and purposes can also be derogated. If you think about the kinds of emergencies we are talking about in terms of what it means to derogate, human rights. Section 37 of the 1996 South African Constitution speaks specifically about non-derogable rights. So in that sense, you can possibly say that the South African 1996 Constitution specifically mentions or is specifically concerned about Cogens norms, while the 2010 Kenyan Constitution is not concerned or does not specifically or explicitly mention Cogens norms. And that can create its own problems, especially when we're talking about, emergencies, including a state of emergency, or emergencies that are as serious in terms of, health questions as the coronavirus. So at least as per the latest news, neither South Africa nor Kenya has reported any cases. And we hope it remains that way, because in some of these countries, the health systems are not as strong. At least people are not as, do not feel as secure as people might feel in the global north. Here in the global north, you might feel as if the health system might work, and President Trump has said, we are capable. If my president says we are capable, we take it with a pinch of salt. Maybe I should then mention that, my next slides talk about the fact that these two constitutions are very robust Bill of Rights. And what I mean by a robust Bill of Rights is a Bill of Rights that has the three generations of human rights. It has civil and political rights in that catalog. It has social, economic, and cultural rights, which in very many places, at least in Europe, they're being accepted more. Here in the US, not so much so economic, social, and cultural rights, like the right to housing, the right to, healthcare, as a fundamental human right. And group rights also are included in this Bill of Rights. And these are especially the rights of what have been called the fourth world. You've heard about the fourth world. These are indigenous peoples. And they exist in very many places. In Africa, especially sub-Saharan Africa, the concept of indigeneity, and like, in Australia, in Canada, here in the US and in Latin America, the idea of aboriginality is not as, it's highly contested, because who then is indigenous in Africa? That is questioned. But the concern that has now developed is about so much more about peoples being marginalized and not being taken care of just because they have decided not to enter into the realm of Western modernity and its idea and conception of development. At least Western modernity in terms of how we think about economic development in the Western modernity sense. And that's the group here that we're talking about in terms of indigenous peoples. So that's at least important to mention. So what would you expect? I mean, if you were reading these constitutions without ever going to these countries or without ever interacting with someone who is from this country, you would think that these are, very fair and strong systems. In terms of even democracy, these constitutions are written really well. Some of these constitutions, at least the South African and partly the Kenyan constitution, have been described as the most progressive in the world. And I mean, this is by, outsiders, people like, serious scholars like Cass Sunstein has said that the South African constitution is one of the most progressive constitutions in the world. So you will expect that the lives of people in these countries will be as transformative as the documents that we are talking about. The truth is that they are not. At least when I give a couple of examples, you're going to see why. Okay, so let's start with a bold example. So the first part of that slide is, we have some bold examples. So we have some bold decisions that have come out of these countries that we can say, okay, there is some sense in which we are seeing, decisions that can be said to be transformative, in quotation marks. The zenith, if I may call it, of a human rights hegemony in South Africa is not just the 1996 South African Constitution, but is this important case in South Africa called S versus Makwanyane that struck down the death penalty in South Africa. It is that decision that sort of, announces that South Africa has entered into the global world of human rights discourse as a serious player. It's a 1995 decision. Very, very bold decision. I mean, if you read the decision, you will be amazed by the kind of writing that these justices are doing in that decision. It's very bold. It doesn't stop there. If you go further, you'll find the same-sex marriage decisions in South Africa also being quite bold in the, flowery decisions. There are two decisions of that kind. Again, contesting and pushing forward the boundaries of human rights protection. And it doesn't stop there. You can go to Grootboom. Grootboom is a housing rights decision that the South African Constitutional Court is basically saying that, if someone does not have a place to live, the government should provide housing. In a simple way. I mean, I'm putting it very simply, but I have found that in this country to say that is a little bit, over the top, Saying that is a little bit over the top. But here we have a court that is specifically saying that. You have another decision called the Treatment Action Program case, which specifically says that the government should provide persons who are HIV positive with drugs for free. So if you're thinking about social economic rights, these are very bold decisions, that are coming out of South Africa. Whether they are followed through, whether this is an idea that pervades South Africa constitutionalism is questionable. It is highly contested, okay? So that you don't feel as if I'm painting a very rosy picture. It is highly contested. If you go to Kenya after 2012, you have some beautiful decisions, not as bold as South Africa, but something that you can say, okay, let's do a little bit of celebration for this. Let's toast to this, Francis Mwaruatetu is a decision that specifically does not strike down the death penalty because the death penalty is still in our books in Kenya. What it does is that it says the mandatory death penalty has been struck down. And that means that judges have discretion on whether they are going to, put up the death penalty or not. And it's not, as it were, that once the offense has been committed and once the person has been convicted, then the sentence is mandatorily death. That has been struck down. Whether that is incrementally going to take us towards the striking down of the death penalty is another question altogether. Interestingly, there's a moratorium in Kenya on the death penalty, and no one has been executed since the 80s. So again, concerns that might be similar with what is partly happening here in the US. Now, another decision that is interesting is this EG versus non-governmental organizations, coordinations, and boards, where the Kenyan High Court said that an LGBTQ NGO must and should be registered as a valid NGO in Kenya. This is an interesting decision because, in Kenya, we haven't gotten to where you guys have gotten to on these questions of LGBTQ. In fact, just recently, a Kenyan High Court decision refused to discriminalize, offenses that are of a gay nature. And therefore, in that sense, that idea that we have moved forward is not as accurate. But this is a decision that specifically says that an NGO that is championing for LGBTQ rights must and should be registered. And that sort of conflicts with a decision that then says that you won't decriminalize. Again, whether that is incrementally moving towards saying that soon and maybe very soon, decriminalization might occur. Yeah. Unlike South Africa, where we are talking about same-sex marriages, here in Kenya we are still talking about the low-level goals. Yeah. Decriminalization, registration of an NGO. We haven't gotten to that level of same-sex marriages, at least in the sense that we are speaking about Obergefell here in the United States of America. The last decision in Kenya that is very interesting is, I think the second decision, I think there must have been one from a West African country, I forget which one, that strikes down a presidential election. And this happens in 2017, where the Supreme Court of Kenya says that these elections were not held in a free and fair manner. And this is the second decision, I think maybe the third in the world, where a court is specifically entering into, what I think one justice in the US called the political thicket, and issuing a decision that really, really enters into what here in the US will be considered, political question doctrine 101. Why would a court be ruling on the elections? And this is really saying that the elections were not held in a manner that is free and fair. So that in itself is a very bold move in terms of how the courts in these countries have become strong players that are issuing emblematic decisions that are saying something to the world, not just decisions that have a transformative agenda in this country. So that's my celebratory stroke. The sad story is this one, that this progress, both in South Africa and in Kenya, is just painting a legal story. There has been continued discrimination, poverty, serious poverty, subjugation and alienation of individuals and peoples, living below what one serious sociologist and sociological scholar called Boaventura de Souza Santos has called people living below the abyssal line. These are people who have been subjugated and discriminated by systems in their countries because either they are minorities in one sense or the other, and most of the time these people are poor people. A high number of them live in the global south, but there's an increasing number of them that also live right here in the global north. So when I speak about people living below the abyssal line, I'm mainly speaking about indigenous communities whose rights have been violated, minority groups whose rights have not been granted or accepted, both in the global south and in the global north. And this idea, especially from an economic angle, pervades both Kenya and South Africa, and I would even extend it to most of the global south. So that's something we sort of need to think about while thinking about this as celebratory decisions. Why is it that there is still high poverty rates in South Africa and in Kenya? And why is it that in South Africa, most of the minority white community has still benefited or continues to benefit, from the possession of land and economic opportunities that most of the black majority has not been able to get? And in Kenya, that line is drawn based on political elitism. So mainly if you are connected to politics in Kenya, you might easily be able to move out or through the abyssal line. So they normally say in Kenya, for example, if you know a politician, you might possibly not be poor. So know a politician, and maybe you will move out of poverty. So that's the sad story here, and that's the story that I'm interested in. If the constitutions are supposed to be transformative, at least socioeconomically, why are we having this scenario? Okay, why is it that there is xenophobia in South Africa, and it is mainly against other African immigrants? Maybe we should ask those questions. In a country which says we have the best constitution in the world, you are killing other people just because they are Nigerian? I think we should ask those questions. That is what I call the fragile hegemony of human rights in Kenya and South Africa. It's fragile. You will think that human rights have reached a certain hegemonic sense because we have a robust Bill of Rights, but there is a lot of, that hegemony is very fragile. In fact, I question whether human rights should be this hegemonic in these countries. And that's why I say that a large majority of Kenyans and South Africans are not subjects of human rights. They are just objects of human rights discourses. So that these human rights are emblematic in the sense of, even to some extent, you might think about these states just pantomiming, maybe very highly to the global human rights communities, and sometimes to the global north, so that they can get more capital in terms of foreign direct investment and things of that sort. So it's not human rights discourses because people are very interested in the transformation of the lives of the people living below the abyssal line, but there are other issues. And therefore we ask ourselves, how can human rights be efficacious to the struggles of the excluded, exploited, and the discriminated, especially in the global south? And why, importantly, very, very importantly, why isn't so much human suffering? If you've been to Africa and some other places in the global south, as a geographical entity, you might know this. Why isn't this immense human suffering that is, in some sense, deplorable to think about the fact that such, human beings will live like this? Why isn't this considered a violation of human rights? Why isn't this a Cogens norms that people can live deplorable lives, especially in the global south, as we think about Cogens norms? Evidently, I'm raising these questions so that we really think about them, but these are important concerns if at all we are saying that the scripts of human rights or human rights, the human rights language can emancipate people. Can it really? So I ask, for example, what other discourses of human dignity are there in the world? Samuel Moyn has written an interesting book called The Last Utopia, essentially saying that human rights are the last utopia. Okay. And Anthony Engi wrote a response to that book saying, whose last utopia? Because for the people of the global south, they don't know human rights. At least they have not seen human rights as subjects. They have only experienced human rights as objects of the human rights discourse. So if you say this is the last utopia, what is left for the peoples of the global south? What is left for the people who are living below the abyssal line? Not just in the global south, but even here in the global north. What is left, for example, for the people who face or have faced serious torture in Guantanamo Bay? If human rights are the last utopia and human rights cannot speak for them, yeah, we need to think about that, because there's a sense in which you will see a cultural divide, what Professor Anthony Engi has called a cultural difference that divides people along that abyssal line. Most of the people who are on one side of that line are people who are coming out of the metropolitan world, especially in our case, people who have benefited out of colonialism or political elitism. And so people who are on the other side of the abyssal line are mainly black communities in Africa or racial minorities in the global north who are facing from serious exclusions, which we need to think about. So maybe Cogens norms are not as counter-hegemonic enough to transform the lives of these people, to change the lives of people who are living below the abyssal line. Maybe we need to start other narratives. What are these other scripts of emancipation or of human dignity that have existed, because at least in the global south, rather in the global north, there's a last utopia. Human rights is it. There is not any other script of human dignity. Can there be? Is it possible? So that then we don't stick to the falsity of this, flowery language in the constitutions that do not transform into reality among the people. Yeah, so I guess that those are some of the concerns that I think about when thinking about use Cogens in these countries. And if you want to think more about this, conception, you'll think about what Boaventura de Sousa Santos says about colonialism. And this is important because it says that, it is his contention that the Abyssal Line, which produces radical exclusions, far from being eliminated with the end of historical colonialism, at least in Africa, continues to exist, and that its exclusions are carried out by other means. So we speak about NeoColonialism, we speak about racism, we speak about xenophobia, we speak about the exclusions of perceived terrorists, we speak about undocumented migrants, and we speak about asylum seekers as a category of people who are living below the abyssal line. And let me tell you an interesting narrative. The death penalty in South Africa, at least some scholars have argued, was not eliminated mainly because, as part, it was all emblematic, but it was also because for a long time, the African National Congress, which is the leading party in South Africa, had been against the death penalty, and mainly because in the 80s and before that, the number of people who were being executed were predominantly black. And the ANC was saying, if that is what the death penalty is going to do, just because of that, then the death penalty should be struck down. So there was, majoritarian support for the striking down of the death penalty in South Africa. If you want to think about majoritarian support in the Alexander Beckel way of thinking about counter-majoritarianism, not as counter-majoritarianism against the people, but counter-majoritarianism against or going together with the biggest political party that has been, elected. So that is important to think. Now, there are certain ideas that have perpetuated this falsity. There are certain four ideas that I like to present as I now, move towards the end of this discussion that have perpetuated this problem that I'm speaking about. Now, evidently, I've tried to show you the two pictures, If you are going to the city that I come from in Nairobi, I will not have done to you the injustice of only taking you to the slums. I've taken you to the suburban parts and nice malls in Nairobi, but I've also shown you the filth that is in the Nairobi slums. What will happen to you most of the time as a foreigner in Nairobi, you will be taken to see the filth that is in the biggest slum in Africa called Kibera. But I've shown you that there are good things that are happening, but there are evidently bad things that are happening. And how do we, contest these ideas? That's my intention. So that then, the peoples who are poor, the peoples who have been excluded can, get a better life, if ever they will get a better life. So in terms of, hegemonic human rights, that these four ideas, which I mainly get out of, Boaventura's work, of saying that human rights, at least with their Western origin, and this is important because most of the scholars who have spoken about cultural relativism, including a very important, Kenyan scholar who lives and works here in the United States called Makau Mutua, is that human rights have a Western origin. And at least that, some of us are not willing to say that that is in itself a bad thing, because human rights have a huge claim towards universal emancipation. And in certain cases, it has made it possible for us to know certain human rights violations that we'll never know. But because of that, we have had a cognitive injustice. Because human rights have a Western origin, there's been some cognitive injustice, that which therefore thinks about Europe as the teleos, or human rights as the teleos is more important than anything that is coming out of these communities. So it's some sense in which that human dignity is not respected in traditional African societies. That's the point of teleology. That you will go to a community, especially in an African community, and say, these people are barbaric, they are backward, without questioning ever if these people have any sense of dignity in these communities, any scripts of dignity. And I present to you, and I highly persuade you that these communities previously and now still have very serious scripts of human dignity. But the teleos of human rights has completely eliminated that, and in some sense relegated it to a sense of barbarism. And therefore, these communities cannot have any, cannot have any counter-hegemonic conceptions. Evidently, and importantly, these communities also have some very bad conceptions of human dignity. But this is also true in the global north. This is also true in the West. If it is accepted in the West that there are certain ideas that are, repugnant, that is the word that the colonialists use to describe most of African culture, repugnant to justice and morality. We call it the repugnancy clause. And most of the time it was incidentally to say that everything, or most of the things that of African culture are repugnant to justice and morality. So one judge in a famous Kenyan case called the payment of the bride price to be this abominable African practice of wife purchase. Crazy for an African to hear, because it isn't wife purchase in that sense if you took some time to try to understand it without just relegating it to a situation of repugnance. But that is the teleological problem. There is also the triumphalic problem, that human rights are triumphant. At least for me, that's the Samuel Moyn problem. That we don't question them, we don't ask, we don't look at the fact that it is possible that human rights have been used for both good and bad. And they're triumphatic just because of the fact that they're human rights. And maybe that needs to be questioned. And maybe there is a possibility of creating a counter-hegemonic wave for the peoples who are living below the abyssal line, for the purpose of saying, yes, human rights can emancipate people, but they're not triumphatic just because they're human rights, because there's a possibility that human rights have been used for great and grave injustice. In fact, colonialism, to a large extent, was justified with human rights language in terms of civilization. So think about those kinds of concerns. What about decontextualization? And this is very much tied to teleology. You get into a community, you don't contextualize that community, and you don't ask, what is good for this community? And how can we ensure that we protect these communities using their own scripts? This, I believe that, if you want to deal with Islamic communities and human rights, you cannot enter with a decontextual mentality. You have to enter with a very contextual mentality. And it is only Islamic conceptions, for example, that can be used to convince Muslims of human rights, of human rights views. And I've spoken to some of my students in Kenya about this, for example. You can't just go to some of my students who are Muslims in Kenya and tell them, you know what, this idea of polygamy, it's really bad. I mean, they will look at you as crazy unless you try to speak with them and understand the scripts from which, they understand this idea of polygamy from. But the human rights idea, the human rights program has been, a top-down program. Get into that community and tell them that that is bad. Let me give you one good example. I call it female genital surgeries. Human rights scholars will call it female genital mutilation. Notice the language there. Very importantly, I do that because FGM is the best example of how not to counteract cultural practices that can in themselves be, against women, women rights. In Kenya, you find a situation where you just come up with an act called the FGM Act that makes it criminal. Okay? And then the community still practices it in secret, and many girls end up sometimes going through very unsurgical processes and die because of these processes. So what about us trying to speak to these communities and trying in a very counter-hegemonic angle to understand where they're coming from with these communities and try to see how we can change these practices from within, using the scripts, using the languages, using the ideas that these communities understand. Maybe this can help us change. There is a great scholar at Emory called Abdullah Anahim, who has written very strongly about this, especially from an Islamic angle. I really advise you to check him out. Great scholarship on these ideas. The last one is this idea of monolithism, that human rights is one thing, that we are one big, happy human rights family. Yet the truth is that, there are generations, there are civil and political rights, there are social and economic rights that some countries don't agree with. The United States has been very vocal against this. There are group rights that some people say cannot be realized. What is the right to peace, for example? What is the right to development? How do you speak about the right to development? It's not monolithic. It's very many things. So it's not one big happy house. At least the way I see it. Finally, and I'm sorry that this might end in a bit of a sad note. This, at least for Kenya and most of Africa, these three concerns must be tackled, head on. If we want to deal with complete emancipation, colonialism, and the continuities of colonialism have to be addressed. So the idea that colonialism ended is not accurate. I'm speaking about the continuities of colonialism. If we are to have emancipation and human rights recognition, we have to deal with chronic capitalism. I really think so. And of course, both from a Western and from a very cultural, relevant African angle and religious angle, we must deal with patriarchy. Otherwise, at least in the case of Kenya and South Africa, we will remain with flowery constitutional language that has very little for reality for the peoples who are living in these countries in the global south. Thank you very much.
So in the interest of time, I know for some of you, you may need to go, and we are at the juncture of an hour. And so, of course, we bid you adieu and thank you for your time. For those who are able to stay, we'll have discussions for about another 10 minutes, and then we'll adjourn to the rotunda for refreshment, and where you can also talk with Professor Mbori at greater length. So that is officially the end of the program for CLE purposes, but please, you're welcome to stay. And would love to entertain a few questions.
Okay.
Thank you. Thank you for coming, and thank you for taking the time, of what looks like a really well-researched paper, or presentation. My question to you is your concept of how fragile the situation is, and that could be receptive to any other part of Africa, thinking about the healthcare system, the governance structure, the public institutions or private entities, so it's always fragile. So, but my question to you is specifically relating to Kenya. It has a bit of a political sensitivity note to it. I think after the 2010 election violence and things like that, and now we have the formation of the Jubilee Party. So what do you think? Do you think that is just trying to calm down the high stake and the sensitivity towards the tribal and security issues that comes with election violence in Kenya? because it is not something that is new. It is not something that is new in other parts of Africa. And now you have Al-Shabaab, that also is creating a security issue around Kenya, Somalia, and other parts of Africa. So do you really think, a human rights framework will be the answer? Or do you think we have to reconceptualize what we do as a continent, but more so specifically Kenya, because Kenya is a very massive economy and a country in Africa. So, so what is your take on that?
Thanks for that very elaborate question. I would say from a security point and thinking about the Al-Shabaab challenge, this is a very similar sort of a challenge that the United States has had, with any sort of terrorist organization. What I am sure about is that there is a high possibility for a human rights framework to deal with this kind of a concern. But it has to be a very counter-hegemonic human rights framework, not the Western-centric human rights framework that we have seen. So, for example, the question of how the youth are being radicalized is tied, at least for one example, to radical Islamism, true, but it also is tied more to unemployment. And then what is causing unemployment is economic deprivation. What is causing economic deprivation goes back to some of the things that we have been, speaking about that have an historic content. So there is a possibility of emancipation through a very counter-hegemonic, human rights structure to deal with some of these problems. I don't think, that the Kenyan government, and I don't think that even here in the US, that most governments, take enough time to think about the question of radicalization and how to deal with radicalization. It's always, let's just go and bomb them. And that creates even more problems. So that's how I see it. Now, if you go to the other part of your question on the politics of ethnicity, I have been of the view that, ethnic nationalism in most of Africa has no problem. Ethnic nationalism in Kenya has no problem. The political elite, through, the politics of divide and rule, which we learned best from the Britons who colonized us, have been able to perpetuate, these problems. So that's why you see that these concerns of political exclusion become even more during times of elections. But otherwise, most Kenyans, in terms of, ethnic, sustainability, can just stay together. And I don't think that this government, at least the way it is structured, has removed Kenya from its problems. It's maybe some sort of tenuous peace. It's never real peace that, is sustainable. Yeah. There's one here, and then there's another one on this end. So maybe we finish this side, and then we come here.
First of all, I guess thank you so much. I learned a lot, and I have kind of related to what you had been talking about, specifically with the intersection of colonialism and crony capitalism, when you were saying these two things need to be addressed. So that takes me to sort of, like you had mentioned, foreign direct investment and corporate activity on the African continent in general. And so I was wondering whether you know of any courts on the continent or in Kenya or South Africa that have specifically looked at the questions of human rights abuses, when, especially like in the context of child slavery in the West African cocoa plantations and other things like that. And whether or not you think that is even possible to address in courts in Africa, or if there's another way to address issues where you have foreign corporations coming in and allowing sort of rampant issues of enslavement and trafficking and things like that.
Yeah. So that is a very important concern, at least in terms of African judicialism. You see, most of the judiciaries in Africa have not been as strong as you'll expect. I mean, you see, these emerging democracies, South Africa, Kenya, the judiciaries try. But there's a subsection of courts that are mainly ignored when we are speaking about some of these concerns that have at least have started to have some teeth and some naming and shaming, not necessarily compliance, but these are regional human rights and regional and sub-regional sort of courts in Africa, and they are quite impressive cases that have gone, for example, to the African Court on Human Rights. Many cases that specifically address some of these concerns that you have raised have been raised. There are structural concerns there, but important. If you go closer to the west, you could go to the ECOWAS Court of Justice, which now has a specific human rights mandate and is doing some very good work. I mean, in the east, we have the East Africa Court of Justice that also has been receiving human rights cases. The truth is that there's been backlash in the south. There's the South Africa Development Community Tribunal that had human rights cases that were very sensitive in relation to land in South Africa. Then that avenue was closed up. But these entities are doing very well, at least both in terms of the economic questions. If you go to OHADA in Francophone Africa, doing very, very good work that is EU level supranationality, actually. And not so much human rights, but OHADA is doing close to EU level supranationality. But these are sort of ignored entities. But if you forage through your research a little bit, you might be able to find very interesting cases and concerns. Yeah.
Thank you for your fascinating human rights presentation. I have a question that doesn't directly address the presentation, however. It's more of a personal question, and that's because we have a number of SJD students in the moot court room right now listening to your presentation, and I thought you might have some interesting insights to share about your experience as a researcher and writer here in your SJD program.
Yeah.
And if you don't mind.
Yeah, of course. I don't mind. I'll share. So interestingly, the question that was just asked is right within my research agenda, which is Africa sub-regional and regional courts, both dealing with economic and human rights questions. I am the first international international law and comparative law SJD candidate at Loyola in Chicago. And so for that, being the first, there's, you're being babied and, all those concerns. But the first concern has been to develop as much as possible, sort of reading in the area and to try and, write something not specifically, big enough to be published at the Harvard Law Review, but big enough to be, taken to a publishing house, and people will think that this is an, important contribution, and that's when now they will, release me to go out there and write an SJD thesis. But of course, I can, chat much more about this, when we are having, the session. But that's basically has been my experience. I'm just about to finish my first year, so I have, 2 more to go. Yeah. Thank you so much. Oh, what? Can we take one more?
One more. Yes, we'll end on this note. You get to take us out. Keep it brief, please.
Okay. Thank you for coming. I want to ask you what you think about the African countries that refuse to comply with African Human Rights Court decisions sometimes.
I get that's an important question. I mean, the concerns of compliance have always been, pervading. I mean, will they comply with these decisions? And that's why I said, at least in terms of one, let's think about how the impact of the naming and shaming that these decisions have. Sometimes, they have complete backlash. Sometimes they have very important impact in terms of changing the way the world, other African states, and the interlocutors at the domestic level, the NGOs, the individuals and the people at the domestic level, how they view this state is very important. Most states do not want, to have this decision out there that said you have completely violated human rights. Even though they might not completely comply with it, there is a sense in which once that decision comes out, especially the interlocutors at the domestic level have a very strong move towards pushing the state to comply. Sometimes we end up with a backlash that kills the court, but more than not, we end up with a situation where there is even more pressure on this particular state to comply. But it's a very challenging area. Yeah. Thank you. Thank you very much.
Feel free to ask Harrison more questions outside. Thank you, everyone.
Thank you. I thought you were going to ask me.
Well, I like to show deference. Perhaps I do have questions. Absolutely. Well, you know about this concept of human rights, ritualism.
Yeah.
Yeah. So, I mean, this is sort of the idea of the pantomime, right?
Yes.
But the other idea, I mean, I know I've seen this critique within the U.S. courts in this sort of, there is sort of a political constitution.
You should invite them outside.
If the decisions are not
Join them to talk to them outside.
Thank you. Nice to meet you.
Thank you for coming. Thank you. Appreciate it. I'm Jonathan Gordon. I work with
Great.
and a group of SJD students who are educated.
Okay. Thanks for coming.
Professor from Stratford. So come outside. You can also sneak out the back. SJD students, I'm going to teach you something if you didn't know this. Secret passage.
What year are you?
How are you?